All right, looks like we're almost ready to begin. Is Ms. Rodriguez ready to go? Okay. I'm Josh Aldrich. I'm joined by Hearing Officer Kim Wilson and Keith Long, Administrative Law Judge Keith Long. Hearing reporter Ms. Rodriguez is also present. She is reporting the hearing verbatim. And to ensure that we have an accurate record, please speak one person at a time. If needed, Ms. Rodriguez may stop the hearing and ask for clarification. She may also ask you to slow your rate of speech. After the hearing, Ms. Rodriguez will produce the official hearing transcript, which will be made available on the Office of Tax Appeals website. To help the hearing run smoothly, please mute your microphones if you're not actively speaking. If you see the microphone, there's a red light. That's when it's off, and a green light is when the microphone is on. Please maintain a professional decorum. For example, please do not interrupt the other party while they're speaking. As a reminder, these proceedings are being broadcast live, and any information shared is publicly viewable. It is your responsibility to redact information that you do not wish to be disclosed. Once we go on the record, we will confirm the issues, go over the exhibits, and address other housekeeping matters. With that said, are there any questions before we go on the record? Mr. Vandervalk?
I don't believe so, thank you.
And Mr. Semmer-Grima?
We don't have any, Judge.
Thank you. Okay. This is Judge Aldridge. We're opening the record in the Consolidated Appeals of Jalidat Incorporated, doing business as Texaco, before the Office of Tax Appeals, OTA case numbers 18093749 and 240516251. Today's date is February 19th, 2026, and it's approximately 9:30 a.m. The hearing is being live streamed on OTA's YouTube channel. This hearing is being heard by a panel of 3. My name is Josh Aldrich. I'm the lead administrative law judge for purposes of conducting the hearing. I'm joined by Hearing Officer Kim Wilson and Administrative Law Judge Keith Long. We 3 are co-equal decision makers. As such, during the hearing, panel members may ask questions or otherwise participate to ensure that we have all the information needed to decide these appeals. Excuse me. After the conclusion of the hearing, we will deliberate and decide the issues presented. As a reminder, the Office of Tax Appeals is not a court. It is an independent appeals body. The panel does not engage in ex parte communications. Our opinion will be based off the parties' submissions, the evidence, the relevant law, and the arguments we hear. So everyone knows we've read the parties' submissions, and we're looking forward to hearing your arguments today. Who is present for appellant?
Yes, my name is Andre Vandervalk. I am the CEO. The account that we're talking about is referred to in multiple times.
Mr. Vandervalk, excuse the interruption, but could you bring the mic a bit closer to you?
Yes, the mic. Can you hear me now?
Could you lift it up the top? Yeah.
Okay.
How about now?
Can you hear me now?
Is that better?
Yeah.
Thank you.
Okay, I may have to shuffle a little bit, but my name is Andre Vandervalk. The account that we're talking about has been identified as a Texaco, as a Chevron, and at one time as a Shell. And there's reasons for that. I am the CEO. I am the person responsible for every piece of paper that I've given you over the last 2 decades. That's how old the account is, or at least the audits and the appeals. My wife is sitting next to me. We've been in the same house for over 50 years. We've been married for 56 years. We'll be 57 years. At this point, she sometimes tells me what I need to hear or maybe reiterate and things like that. I want to, if I can, open the meeting with saying that I don't have anything to hide. This is not a case of where.
So, Mr.
Uh,
Vandervalk, right now I'm just asking for
Okay,
names.
And I
Who's present?
appreciate that.
Okay,
I do have some stories to tell. Thank you.
okay. And Ms. Vandervalk?
Linda Vandervalk.
Thank you. And for respondent or CDTFA, or California Department of Tax and Fee Administration, which I may refer to as CDTFA.
Nalan Samaravikrama, hearing representative for CDTFA.
Jason Parker, Chief of Headquarters Operations Bureau with CDTFA.
Good morning. Christopher Brooks, attorney for CDTFA.
Thank you. So with respect to the issues, there's 2 appeals before OTA, each with a respective liability period. The first liability period is April 1st, 2004 through March 31st, 2007, which I'll refer to as liability period 1. The second liability period is January 1st, 2010 through December 31st, 2012, which I may refer to as liability period 2. For liability period 1, there are 4 issues. 1, whether appellant has shown that further adjustments are warranted to the audited difference between recorded and reported taxable sales. 2, whether appellant has shown that further adjustments are warranted to the audited understatement of reported taxable mini-mart sales. 3, whether appellant has established that its sales of propane are exempt. 4, whether the negligence penalty was properly imposed. For liability period 2, the issues to be decided are as follows. 1, whether appellant has shown that adjustments are warranted to the audited difference between recorded and reported taxable gasoline sales, taxable diesel fuel sales, taxable mini-market sales, and sales of propane. Issue 2, for liability period 2, whether appellant has shown that adjustments are warranted to the unreported taxable cigarette rebates. And 3, whether the negligence penalty was properly imposed. Mr. Vandervalk, is that a correct?
That's a good assessment, yes.
Okay. And Mr. Samrak-Rima, is that your understanding of the issues?
Yes, Judge.
Okay. I do have some questions with respect to issue 3 of liability period 1, and I'll go ahead and pose those. Mr. Vandervalk, you may want to address that during your opening presentation, but one second. So on March 11th, 2024, the Office of Tax Appeals received an additional brief from appellant's counsel, wherein counsel responded to 7 questions that were originally posed in the form of an AB, or additional brief request. In those 7 questions, one of the things that was conceded was that the sales of propane were not exempt. Is that still, do you still concede that, or do you dispute the sales of propane being exempt?
That may need a somewhat explanation. If you care to hear it, I'll be more than glad. I don't have to refer to it. I know which item that you're talking about. What happened, there was additional audits, 3 and 4 I call them, that were taken, and at that particular point in time, it was the same auditor that had done the first audit. And I mentioned to him that, look, you've already figured all this out. Here's the thing, I did not collect sales tax on those, on the
Propane
item
sales?
on the propane sales. I said, but I'll concede to this audit, and I will start, and the reason why is I'm collecting now. I said, I got, okay, I am collecting the sales tax now for this third and fourth audit. I will pay that.
So,
And at
with
that point, but I'm open. I think that in this particular case, it's a minor part of what, of what this is all about. And I would like to hear what at that time with the BOE, if you're not collecting sales tax and you're under the understanding, and that's what the understanding was, that a 30-gallon tank, which is what the
so Mr.
items are.
Vandervalk, you're welcome to address that during
Okay.
your presentation.
Okay.
I was just hoping to have some clarification there. Did you have a question, Hearing Officer Wilson?
That's
Okay.
what the concession was during the third and fourth audit.
Okay. Thank you. And at this time, I'm going to turn to the exhibits. As memorialized in our office, in the Office of Tax Appeals, January 23rd, 2026 minutes and orders of pre-hearing conference, Mr. Vandervalk, you indicated that you were having trouble opening CDTFA or respondent submission. In response, I'd indicated that we would be sending you a hard copy as well as a CD with a PDF of that submission. Did you receive the hard copy and or CD?
Yes, I received both. Thank you,
Okay.
Judge.
I just want to make sure that you have everything you need to proceed.
Well, if I can add to that, maybe 895 pages is what I received. And I
Okay.
went through every one of them over the last 2 weeks because I received them with very little time.
Okay, and let me just double check something. So I have, my understanding is that what was sent to you is double-sided, but the page count that I have is 900 pages,
895
895.
is what I received. Double-sided. I'm looking at the last, yes. I don't, I think somebody rounded it off, and that's fine, or the count may be off, but
I think you might be referring to the number, the bait stamp number at the bottom, which is 895.
yes.
Okay, all right, so that's in order. So respondent, they submitted exhibits A through P, which was the file that was sent to you in hard copy and the CD format. Do you have any objection to admitting those documents into evidence?
None whatsoever.
Okay, and appellant submitted exhibits labeled as A through G, which we'll relabel and refer to as exhibits 1 through 7, just so we can keep respondents and appellants' exhibits separately identified. 1 will be the overview, 2, the audits, 3, highlights, 4, Jalidat 76 Ocean Inc., 5, fleet cards, 6, sales tax / rack, and 7, card lock model. Respondent, Mr. Samakrima, do you have any objections to admitting appellant's exhibits into evidence?
We have no objection, Judge.
Okay, hearing no objection, exhibits A through P and 1 through 7 are admitted into evidence. And now I want to talk a little bit about how we expect the hearing to run. So we'll proceed as follows. Appellant's opening presentation, including testimony. We allotted 120 minutes for appellant's opening. Then we'll move on to respondents' combined opening and closing for 60 minutes. And then finally, appellant will have 5 to 10 minutes for closing remarks or rebuttal. I've also allotted time for questions from the panel members. And if you need additional time, you can make that request. Regarding witness testimony, Mr. Vander Valk, you indicated that you were going to be providing testimony.
That's correct.
And is Ms. Linda Vander Valk providing testimony today?
To the extent that she was present at a board meeting of the BOE in 2015, she was there when certain commitments were made by people or the representatives of the BOE at the time.
So if she plans on testifying, now would be the time to be sworn in. If you change your mind later in the presentation, you can make the request. Okay.
I think my wife's hesitation is only to the extent that she doesn't want to be sitting outside if she's providing any witness testimony. That's not what we're all about. That's the only reason why she's apprehensive. She was at the meeting when commitments were made by people within the BOE as to what was going to happen.
Okay.
And that's a strong part of my what has transpired since that's 10 years ago now. 11 to the day.
So we operate a little bit more informally than some other legal forums. She wouldn't have to be outside during the oral hearing. Does that change your answer, Ms. Vander Valk?
Yes, I'll be sworn in.
Okay. Mr. Vander Valk, could you raise your right hand? Do you swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you. Ms. Vander Valk, could you raise your right hand? Do you swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you both. You'll remain under oath until the conclusion of the hearing, okay?
Thank you.
So just a reminder, we're the only hearing on calendar for today, but I ask that the witnesses make a constructive use of time. That is, the testimony should be relevant to the issues, and extraneous information or extra information should be omitted. Both parties, including the witnesses, should understand that we have read the briefs and we have all the evidence available to us. Does either party have a question before we move on to presentations?
I don't believe so, no.
Okay, Mr. Samarakwema?
No, Judge.
All right. So at this time, Mr. Vander Valk, the floor is yours to proceed with your presentation.
Thank you, Your Honor, and thank you for your accuracy and your tolerance with the way I've want to transpose everybody back to the 60s when we were in infancy in terms of computers and things like this. Also, it was me who graduated from high school in 1965. I was drafted into the U.S. Army, served in Vietnam as a combat veteran for 13 months. And I mention this because one of my last assignments were to fly into Laos and Cambodia. I had a top secret clearance, and we were delivering money in large volumes in what at that time was a case that was probably this big to this size. I mentioned that because despite that I was 20 years old, an E5 buck sergeant, and we were being fired upon until we settled in those areas. And I'm not jeopardizing what was a top secret clearance because I never had an exit in terms of releasing that. The reason I mention that is because all that cash, all that money, 20 years old, it would have been easy to skim off the top. All I had was 2 pilots, myself, a second lieutenant, and the 2 door gunners. I never took a dollar off of that. I've raised my kids, my grandkids, to reflect the same things. All the way when I got out, I started in 1965 with Union Oil. When I got out, I went right back on a Saturday and went back to work on a Monday morning. And they hired me back in. I had every marketing position, retail, with Union Oil prior to 1989, starting from a sea salesman working out on the service station when I was 18, all the way to when I left in 1989. Every position. In that position, I also met somebody by the name of Norm Rice. Norm Rice and I went back when I was the operations manager of approximately 1,700 stations. And he wanted to they had a new program, and they were requesting volumes of sales or purchases from the oil company. This would have been back in the early 80s. And I mention it because Norm Rice and I reached an agreement when I was in that position with the oil company of providing the information necessary that they still use to this date, and that is volume, gasoline volume on a net basis. And we provided it in lieu of, he said, I can get a subpoena. I said, you're gonna get a subpoena for each location that you're asking about? And obviously, the intent was to keep, during the auditing process, to keep it simple. And so I conceded and said, we'll go ahead and we'll deal with that. I take you now to when I left Union Oil in 1989. I went into business for myself. I had some opportunities to pick up some locations. I was in a growth mode, and that's what you're seeing. But you're seeing a growth mode when I had a service station right next to your Van Nuys office, and I re-met, I should say, a number of people, including Norm Rice as the chief auditor in the Van Nuys branch. Among that, there was also, I had good coffee, I had things where the auditors would spend time with me and everything. I pulled Norm Rice aside and I said, Norm, I've got an opportunity with an outfit called Fuelman. They're willing to go ahead and provide me the credit card or the credit ways of selling to a commercial account. And this was something new that nobody had seen yet. I have the tickets that are here, and I showed them the tickets, and I said, what I'm gonna do, there's 3 copies here. The first copy goes to the customer. The last copy, which is a hard copy, goes to Fuelman, and then I get reimbursed for them. I said, the question is, how do I deal with this? At that time and continuing, I am identified as a SG account. They think that I have a retail business out there that is that somehow identifies with an SG, which is basically a non-attended service station. And Fuelman, Fleet Card, all of them now, everybody, oh yeah, this is, you probably are carrying, working for the state, a Voyager card. No problems, no nothing. But at that particular point in time, we didn't have the computerization, and I have several examples of that. We had a real simplistic system. Norm at that time said, what are you doing? And I said, well, here's it, and I explained to him the 3 copies, and I said, then I carry the items in my the charge items on a daily basis. I go ahead and I carry it under my accounts receivable. When they pay, it reduces my accounts receivable, end of story. He says, that sounds realistic, that, you know, okay. That was my connection. Now, I've been referred to as being, you know, the penalties that and everything else, that I didn't receive notification or communications with the BOE people were non-existent. I didn't have to. They walked to me, and I talked to them. And I got a great reputation all the way along with all of the individuals who have done my audits, the collections people who were as a result of those audits, and that's another story. But what happened was I considered that to be my goal. Unfortunately, Norm Rice passed away in June of 2021. Otherwise, I would have used him as a witness to say, Norm, did we have that? I did get and it's in my notes, and you've captured it also. I had a good friend that I worked with that said, yes, that was the understanding, that you carried it as accounts receivable and that we would pay you. I wasn't satisfied with that whole system. I left them after roughly, it entices both the first and the second audit. But that was my source. I mentioned to you about where I go and what I do. I'm very open. I'm very open as far as any of the information that I have, that I share. So the first thing that I look at is that what is the connection between all of the audits? And the fact of the matter is that it's still to this day. I just had an audit last year, and the same thing. If I don't sign the form that gives an extension, then they're going to go ahead and estimate, and they're going to use the prior percentage of error, is the quote. And in every case that was used, that on the second audit, the third audit, the fourth audit, until I corrected the third and fourth audit and said, no, I gave you the information, and I'm not, I'm not signing it. And then in the end, I did sign that. And there was a major difference. And so that prior percentage of error is very harmful, and especially it should never get to that point, because part of your rules at that time, and this is coming from, again, my association with good people within the BOE and now CDTFA, is that it indicates that the next audit should not take place until the first audit's resolved. And I may be wrong on the resolved part of it, but the fact is that I should never have gone into the second audit. There's a third audit that took place, and the third audit, it's actually not the third audit. On the second audit, because of my reluctancy to sign the form to extend the time, that particular audit, the auditor decided to go ahead and open up another account. Guess what? Under an SG account. Then he referred to it, saying that I should have been, and I state an SG account,
Mr.
explaining
Vandervalk?
that means that it's another entity that I don't fall under. But I continually, there's a mix-up between BOE, CDTFA to this day as far as the identification of an account that actually is a card lock account. And the minute you're identified as a card lock account, for one, based on the auditors that I've spoken to, you're automatically suspicious.
Mr. Vandervalk, you referred to first, second, third, fourth audit.
Right.
So there are only 2 audits currently
That's
before
correct.
us. Which in those series are the 2 audits that you're referring to? So is
On the second audit, I'm sorry, and thank you for clarifying that. On the second audit, for the same period of time, there's a third
what
the-
period of time is that?
76. That was the second. Yeah, it was the 2010, January 1st, 2010 to December 31st, 2012.
So when you refer to the first audit, that's the 2004 through 2007?
Yes,
Okay. And the second audit is the second liability period we've identified as January 1st, 2010 through December 31st, 2012?
correct.
Okay.
And what I'm referring to is that there was a completely separate entity that the auditor created, which is in excess of $700,000 liability now, and it's called 76 Ocean, completely different account number. You were still trying to collect on that entity. And if you take a look at the breakdown of that, you can see, and it's identified, it's identified on my, that's okay, honey, 25 and 26 under my submission. That's the page numbers. Okay, and it says sales and tax use account number, and it has the 017-803-647. But there's another account number.
That looks like it's Exhibit D, which we relabeled as Exhibit 4, correct? It's
Yeah, and
the
then I
top
have
of the
the
page
individual-
says Jalidat Incorporated,
Right.
76 Ocean Incorporated.
That's it.
Okay.
Yes, okay. If you look at that, it says, period beginning under the second paragraph, if I can call it that, it says 1 January 2010 and then 31 December 2012. That's for the account number of Jalidat. And it says final billing 1,856,225.42.
I guess I'm not sure what the relevance of the Ocean 76 is when these two appeals only involve Jalidat and the 4 locations.
Except that for that same period of time, you continue to try and collect for that same period under the 76
You mean CDTFA
Ocean.
attempts
Yes,
to collect?
well, it started out with BOE, now TFA. For $690,000 you're collecting, 690, 596, 11. And it's like the hidden account. Wait a minute, why you, and it even showed up under your top 500 list, which prevented me, and this direct influence on the second audit. And my statement is this, is that the auditor decided upon himself to go ahead and set up a new account for the same period of time. At the same token, I'm indicating, wait a minute, what are you doing? You're billing, it's a big part of what I'm contesting, not only for that reason, but how can you eliminate that? Nobody wants to address that. And to this day, I'm still getting collection notices, and I get notices to my bank that says that they're looking for money. And they're basically, a notice of levy was as recently as February 27, 2025. If this is something new, I'd like to at least, and that's the reason why I provided the information to the, in the system, to indicate, hey, this is not acceptable. As far as I'm concerned, from a business standpoint, how can you be collecting something for the same period of time? It happens to be a different amounts of money that was paid originally through the account, the Jalidat account. To this day, the only function it has is paying the sales tax on a every 3-month basis. It's flawless right now, except for the 2 audits. Everything is paid because at one time, I didn't have the funds. In fact, as recently as last year, the reason why I'm not represented by council right now is I couldn't afford the $52,000 that I was paying all of last year every month. Yeah, it was every month in the collection process, because I realized that what is happening is this collection, right now, there's no change. If you disagree with an audit, or if you go in an audit and you haven't signed that form, they will go with my quote, prior percentage of error. And that happened in the second audit, and there were new billings under a different account. I was identified in the first place as they thought I was a card lock. And that signifies, like I said, to this day, the auditors out there, they're not getting the Norm Rice model of volumes on SG accounts, or card lock accounts. They're not getting that on a regular routine basis, nor are they identifying, they go out and they audit me, and I've had for 2 decades now a cloud hanging over me, but they're not going out to find out what's going on with sales as it is today, which is through the credit cards, such as Voyager and all of the other accounts. Again, I remind you, this was in its infancy. I was in a growing spurt. I was doing lots of volume. And unfortunately, there wasn't the technology available. You'll see some invoices in there in my submissions, and it's I believe it was in your submissions also, where you look at it, it's like an adding machine tape. That was the extent of it. So I, again, looking at trying to keep things simple and looking at, and I appreciate the fact that you wanted to address certain items. I think this is a big part of where we're at. The other part of where we're at is that if you take a look at the first audit, and I'm skipping around between them, but they're all consistent. If you look at the first audit, you went back and corrected the first audit. Now, that's not in your collection process or your identification. That number does not show up, but there was $300,000 difference.
Mr. Van der Valk, when you indicate you went back and corrected it, are you referring to, I believe you're referring to responded, revised it. Is that correct? So the Office of Tax Appeals is independent of any tax agency. We're set apart. Okay.
And I may have confusion. I'm skipping around, which I try not to. But, the amount of pages that I received, there's some consistency as to what's transpired. And that is my identification as a account that I'm not, a card lock account. And I'm identifying the fact that to this day, you are not auditing the large credit card firms that probably represent 40% of my business now. The Voyager, the new Fuel Man, because Fuel Man went broke and then they were bought by somebody else, and all of the other entities that by your own records that I received, it shows that you're not doing a very good audit of using the volumes because you're not getting the accurate volume from those SG accounts or from the card lock accounts. And so I'm looking and saying, why haven't, in fact, they identified and said that, in the papers that were submitted to me, there is a reference there about that they went back and tried to get the information. They communicated with Fuel Man. Fuel Man gave them some things relative to an ARCO station, this, that. That was not my account. And so there's a lot of inaccuracies in this thing. Can I break down each and every one of them? Absolutely. It's not as easy as it is in posting and saying that these are the highlights. And I was gonna go back, you probably had 3 or 4 different pages that was my, would have been my opening remarks, but I thought it was important to identify. But on page 82, starting on page 82 and 83, you, and I'll give you a second to go to it.
Mr. Vandervalk, are you referring to respondent submission, page
Yes.
83?
Yes,
With the bait stamp, 83?
82 and 83.
Okay.
Oh, thank you.
I'm there.
Okay, what I was referring to, and this was posted at least 3 or 4 times under different, you obviously picked up, somebody picked up this, it was under different pages also. But it goes back to what I've basically have so far covered. But it's the inaccuracy. I accept Fuelman as a commercial customer alternative to the credit card. At one time, I had 6 Texaco stations. This is on page 275, first paragraph. And I represent almost 60% of branded sales in the San Fernando Valley. In the audit years, sales to Fuelman were deducted from gross sales as Fuelman pays the sales tax as it bills the customer. Payments by Fuelman were weekly. As with credit card receipts, the information was on hand for 6 months and then destroyed. And that's standard for the industry to this day, that hard copies, because of the attempt to take the credit card numbers and all pertinent information and use them for other uses. So to this day, you keep any credit card or anything that has a credit card number on it, or the last 4, and I shred them. But that's the standard. So that's why I don't have the proof. But I'm going to continue. I now find out the state does not directly process confirmation from any of the third-party wholesale vendors, including Fuelman, CFN, Ride Express, Fleet One Voyager, and Pacific Pride. I know in the startup period of this process, double sales tax were paid by myself and the process company. I extend that now to today. I had Amazon go to one of my modern stations. All the technology is there and the new dispensers and everything else. Amazon wanted a 30-cent discount. And I said, okay, it's worth the business, let's go for it. They could not, the credit card company could not handle the 30 cents. If a customer has with one of the other cards, has a contract, they basically, the dollars roll back. So if you have a 10-cent discount, for instance, and your company has signed up, and I'm sure that the State Board of Equalization or the CDTFA, I'm sure that their credit cards, they have, could be a 6-cent discount, and you'll see it. It'll roll up, boom. It kicks out a nice computerized report then that the state acknowledges is fine. But on the 30 cents a gallon, I sold them for almost a year at 30 cents a gallon, and I was told by the credit card company that the CDTFA could not process that. I would have to hand do it. Now, this is 2 decades ago, because it shows up, that 30 cents a gallon shows up that one of the largest retail, as far as I'm concerned, they have retail, wholesale, however you want to identify them, but it cannot identify the 30 cents a gallon on a rollback basis. I have the technology now, but I have to report it as a as a chargeback. So, as a chargeback, that's tax included price. So that opens up a full door. But the fact of the matter is, in the people who I talk to, because I've rekindled my connections, and you don't have a process to be able to go after those accounts and say, okay, are you double taxing? Who's the end user? Because the end user should be paying the sales tax on the process, the amount of money that goes through that Voyager, or now through the Fuel Man. Not at the time, that we're talking 2 decades ago, but now, that should be rolled back right at the pump. And I was told, like I said, as recently as a year ago, oh no, we can't do that, by the credit card company and by my sources with the CDTFA. Does that open up another question? Absolutely. You're trying to get the little guy who's saying that right now, you're probably collecting sales tax twice. Once from me and once from the person who bills you. That's the only way they can do it. And I've included a copy of what it should be, the billing. The billing should be when they buy through a retail station like myself, it should be through the end user. That end user should be receiving a bill for that, for the accurate. But you don't have a process to be able to go back in then. And here I've been fighting it and looking at, this is a multitude of information. I go back to what I was trying to accomplish with this, going back on July the 3rd, 2008, was to remedy the situation before the 2015 meeting that we had with the BOE. And if I'm not skipping around a little bit too quick for you, but there were 2 people there at this was the 2015 board meeting. It's one of the last ones. In fact, it could have been the last one. And the people that were sitting there, one is a judge now, or he may not be. The other one was actually director of the BOE. And subsequently, not then. He was representing the BOE. And when I brought up the Fuel Man, it was embarrassing because nobody knew except for Senator Runner at that time. He said, what, can you explain it to me? And I did. And it was like, from the 2 representatives that were there, it was like, they didn't know who Fuel Man, what the process was, what these sales were all about. And here I am, I'm trying to basically run not only that location with my auditors next door, but just I was in a growth mode. I was opening stations that Texaco was willing to let the lease go on, and I was trying to do it in the right way. But I go back again to what's transpired since then, and between the inaccuracies, between duplication, I was pleased that I found one item that was as a, and I'm not skipping around, but this is a letter on 382. This would be on your submittal on the CDTFA. Let me finish, and I apologize throwing you a lot of things, but at that 2015 board meeting, Senator Runner, as we're sitting there, and the 2 people that represented the BOE had no clue as to what I was talking about with Fuel Man and how the process worked. And so at that particular time, Senator Runner got on his laptop and he said, well, here's Fuel Man right here. You can't, you don't, well, we'll get into it. And the promise at that time was that they would go ahead, and at that time, the second audit was also in process, and I said, you know, I would like to have that. There's some confusion because I closed the station. You were still delivering to one of the stations that I closed. But I said, can you go ahead and put these two together? We'll get back to you, Andre. We'll figure this out. And this was in front of my wife, myself. They were sitting next to us. It was closer than this. And remarkable, since I went back and on your 382, this was an instruction. This is 382, and it actually starts on 381 of your submittals. This was a letter to CFN. It said, I'm sorry, the 381 is from CFN, and it shows what the letter from the State Board of Equalization was from December 7th, 1994. I don't know if you've had a chance to review this, but it was a letter that was sent to Mr. John Fulenkamp, Director, Commercial Fueling Network. Again, it's 382 that I'm referring to. And it says, as you know, there's been considerable discussion regarding the correct application of sales tax to sales of fuel made through fueling networks. Now this, again, I remind you, this is significantly 5 years before somebody could have told me this. What, a decade before? 1994, it would have been 10 years from the 2004. But basically, it says from the state board, from your legal channels, that there's considerable discussion regarding the correct application of sales tax to sales of fuel made through fueling networks. On August 23rd, 1994, I wrote to your attorney, Mr. Gary Herman, and set forth the board's position regarding the sales tax application to the fueling network type sales made by out-of-state foreign participants through interstate host or in-state host facilities. I'm now writing to you more fully to discuss the sales tax application to fueling network type sales. This discussion will include an explanation of the tax application to fueling network type sales by in-state as well as out-of-state foreign participants through an in-state host facilities. He goes on, but he's basically indicating what the rules are for what would have been, should have been showing up, and obviously Norm Rice didn't have it because I'm reading it to. This is 1994, so we can say 3 decades later. End of story. It shows you how CFN should be treated rather. It also would have at least given us some basis in saying, well, what he's saying is that as a retailer, yeah, you're not the same as what you've been identified as. And that's continuous. There's a continual problem of identifying me as a wrong type of a business. Are you? I'm assuming that you've noted what I'm referring to.
You can direct your comments or questions
I'm sorry.
to me, no problem.
I apologize. It's something that I believe slipped through the cracks and that the field didn't get it. Field meaning that the audit people at the station in Van Nuys, or my station in Van Nuys, and your office right next door. So I look back, and then we go back to the first audit, and the final re-audit results. And I believe that what you were talking about was that this was a note from my attorney to myself, and she said, Andre, Cheryl asked me to provide you with an update of the current state of the case status. First, on the earliest audit, as you know, Karen was able, and they talk about Karen is the CPA that was hired in order to, and this is an ex-BOE auditor. She now works as a CPA in the San Fernando Valley, or actually, in the Valley area. It says, first on the earliest audit, as you know, Karen, that's the CPA, was able to identify a major discrepancy with 1 quarter, and the CDTFA conceded that her conclusion was correct. Unfortunately, they only adjusted the 1 quarter, not the entirety of the quarters under the audit. This will be the foundation of our argument once the hearing is scheduled, but until then, we're in a holding pattern. And then the other note that I received, and I went ahead and passed on, was that we also added the following paragraph at the end of the brief to address the negligence penalty. Regarding, and this is what she says, regarding the proposed negligence penalty, given that the understatement was only 13%, and the complexity of the underlying calculations, we respectfully request that the negligence penalty be abated in full. The reason why I could not afford last year to stay in business, because the collection efforts were such that if I didn't pay the $52,000 a month, I would be out of business. One of my questions that I would really like to ask is that how many people, put yourself in my shoes, how many people are not that fortunate to either have the background and the fortitude? This is a $5 million case. I don't make that much. Right now, my personal attributes are my VA amount, the Social Security. Linda gets her Social Security, and my retirement from 76. That's it. I take a nominal sum. I'm not in my growth periods. My 2 sons operate the locations now, but I am still involved with the taxation because of today and what we're talking about. I would like to know how many people are out there, and I'm considered to be an expert in terms of testimony, in terms of my in the service station business or in the fueling business. As we are today, I'm continue doing that. I'm in touch with reality, which is the street, on what pricing is and what's going on. How many people were driven out of business because they couldn't deal with $52,000 a month? So I had to make a decision. I could not, and I don't, I could not afford legal representation plus paying the CDTFA what collections determined were now and then, right there, they were due and payable. And so at this particular point, I'm completely clear, but I'm representing Jalidat Inc. as the president. Where do I go from here? I would probably add it all up and say, where do we go with this? I would like your assistance, and I see the questions that you asked me at least in a positive position of trying to make something that's workable. And that's all I've been trying to do. Since 2015 in the board meeting, that's all I've been trying to do, is to get an audience with somebody. And I realized the OTA was, I believe it was in the 2018, somewhere around there, and I welcome it. This is the first opportunity I've had. To get back to business, I wrote on the presentation, I said, only last year I was forced to drop counsel as the business could not support legal expenses and pay offsetting charges demanded by the CDTFA collection efforts. Those charges have been paid in full, including interest, penalties, and other charges. In good faith, there was never a thought of Jalidat Inc. or myself not paying collected sales tax from the public. If I can, I'd like to go back to the liability for period one, to your 4 items and 3 items on the second audit, and maybe talk about some of the idea, some of the thoughts on that one. Okay. Whether the appellant has shown that further adjustments are warranted to the audited difference between recorded and reporting taxable sales. I have, and you've conceded it, and that was to take it from the $1.3 million difference. And if you look back, you did only 1 quarter of 2007. Why would that, if this was an audit, you would then use those numbers under your prior percentage of error, and you would immediately hit it for the 3-year audit. Well, that would eliminate most of the charges that you're trying to gather from me. So I don't know why you can't accept that as a base and then go forth on that. And then the second part of it is that I'm asking that fuel man and the amounts that are dedicated, the fuel man, that announce the dollar amounts that I've written down. They may be in pencil, but they were given to the auditor at the time. I ask you to accept those numbers, because you have to accept the fact that how would I make up the name or relay the information about what others reminded me of? And that was, oh yeah, no, that sounds good. And that was, again, use these invoices. And the problem is that after 6 months, and of course the the audit was 4 years later. So those were not, we didn't have those available at that particular point in time. If I can, there's some other deductions that I made under that same premise. And I printed, this is an ARCO station, a Shell station. It shows cash price, and it shows the credit card price. And there's typically 10 cents difference. That's the standard. The only reason I'm holding this because I can verbalize it. But this is representative of last week. This is when this picture was taken. What I have done, and there's several indications that wasn't acceptable, but at the time, we were at the tail end of having cash credit. The problem was that cash credit was not on the computer. And so I used the dollar amounts between the cash credit, which was reflected in the charge for credit, and I deducted those off of the sales. Basically, that's the hand way of doing it. The same way as I would do it today for Amazon. Amazon, it shows that I did it as a chargeback, and I'd be sitting here explaining to you what a chargeback and why that happened. So things haven't changed that much. Reason why is because cash credit came back in the early parts of 2000 when this audit was done. Cash credit, nobody was doing it anymore. It fell out of flavor. There was no way. Plus, the technology was changing to where there were other ways of doing it. It was actually showing up on the paperwork. That's my only reason for doing this. In terms of the overall system in determining things, the complexity has to be challenged of how you deal in the collection of taxes. One of your counterparts up here, I included a statement that was made from them, but one of your, an outside, it was actually a Chamber of Commerce that said that all taxes are collected at the rack. He's wrong. All taxes are not collected at the rack. Taxes are collected at the at the time of the sale. Now there may be some adjustments as I referred to, but they're done at the time of the sale, and they are deducted today with the prepay, and that has been, you know, for some time. Now picture this, my average payments are somewhere today, because of the higher price, for 3 months, for 4 stations, are almost $200,000 for 3 months per quarter. So you go, wait a minute, you mean that's the difference between your sales tax and, you know, what the prepay? Yeah, it is. And you go, there's something wrong. You cannot, the complexity, I don't know why you don't bill at the rack for your sales tax, for the approximate amount of whatever it has been, or whatever the case may be. From day one, I've said that. And that was back in the 70s, because they started the sales tax in the 80s on gasoline. And you go, and I may be wrong a few months on that, but not too much. Why aren't you collecting taxes? That works better for me, because I know my competition up the street that happens to be a independent, he's 60 cents a gallon cheaper than me. How can that be? I'll let you determine how that can be. But at this stage of the game, we're not on the same level. You know, I'm not talking about even your collections, or, you know, from that, I'm talking about myself, who has and you've seen it. There is the largest amount in the, I hate to say in the San Fernando Valley, but in the Los Angeles Basin. It's the largest fuel market in the United States. It has been. And no offense to the Bay Area, but, and I'm teasing on that, but on the complexity of sales taxes, there's a 3.5% difference between my station in Simi Valley and the station on Wilshire Boulevard, Santa Monica. 3.5% difference. Your sales tax audits and everything, you can't, it's the complexity of, oh, here's what it is, and then add it up, could be corrected overnight by collecting sales tax, all taxes, at the rack. It would satisfy me, who has a competitor up the street. If you've noticed why there's so many independents lately, it's because they've figured it out. Hey, I can be 60 cents a gallon cheaper and pick up a lot of volume. And then if I put it on a net basis, and all I'm saying on that, because there were adjustments on that, if you look at the net basis, all I do is I don't provide you the volumes, that's all. And where it reflects is on the profit. That's why sometimes you'll have an audit where the difference, and that was one of the audits, the difference between net and gross, instead from, and I received a engineer's calculation of product expansion, the hot fuel versus the, it's significant. It's $200 to $300 during the summertime on one load of fuel and gasoline. And so if I don't provide you the gallons, it's real simple. It's reflected as net gallons. That means I have more in the gross gallons to sell for, and it's reflected in my profitability. Perfectly legitimate. I just don't provide you gasoline volumes, that's all. All of this can be handled. If somebody takes the direction and say, you know what, he's looking at a $5 million penalty, or, we've penalized him. We've already admitted that the first audit has been changed, and we've allowed that change. It needs to be recorrected. But when you really get down to it, if I can walk away saying that, and that's why I gave you a little bit of my background, is that maybe this guy's got something to say. In addition, and I don't want to bore anybody or whatever else, somehow my life has been great. Like I said, 3 kids, healthy, 7 grandkids, healthy, nurse is one of them. The other one's a school teacher. And the next one is attending Arizona State, and he'll be up there working as a server and things like that. And I think his minor is going to change probably, but we're happy with that. We're happy with that. But there's a drive in me, and it started in combat, and it pertains to this day. And that drive has provided me a distinct feel-good feeling during the Northridge earthquake, when I went after and helped and found the 6th person that didn't make it. We were digging with spoons. What am I doing there? And then it also helped when I was driving down the freeway coming home at 3:30 in the afternoon, and Chatsworth had a train wreck. 25 people died. I was helping pull people out at that particular point and made sure that the triage never stopped. By the time that I left, it was 10 o'clock at night or so like that. I'm the guy who stops when I see an accident and there's a need to do something. I'm the guy that spots and say, I'm here. Whatever the outcome is, I'm with you. I want to try and work something out. But by the same token, I'm also a fighter. And that fight is at me right now, but it's in a productive way. There's some major issues in how we collect sales tax through service stations, and I'm reflecting that. And it could be handled if somebody decides that, hey, there is a better way. You don't have to second guess what the prices are going to be for the next year, especially right now. Take a look at your last time, and I'm probably addressing it to the tax agency, but look at this last time that you figured out what the prepay should be and how it's handled, and how it's handled with the commercial accounts that I've identified that I used these 20 years ago for. Getting back to 4 stations that I have, and I mentioned that I have 3.5% difference in sales tax between one and the other. There are, for any one location, there are 4 different tax structures. If you include the sales tax, the gas tax, and the diesel tax. The diesel tax is another thing that I pride myself. I contacted because diesel tax, we overpaid, and at that time it was $58,000, and that would have been for the 4th quarter of 2024. They acknowledged it, they corrected it. When I called back, I had to I was talking to some technicians up in this, I have names, places, times, but they corrected it. 9 months it took the CDTFA in order to put that out in the general public that said, oh, by the way, if you submitted this on this and this, you neglected to have the diesel credit. Like I said, for my numbers, that was $58,000. So when they did issue the credit finally, 3 months later, now mind you, the public didn't hear that until 8 months later. And it was like, oh yeah, you know. Anyway, 3 months later, I received that credit. It was banked to the oldest item, which is supposed to be not happening. You know, the oldest item. It was a direct, it should have been credited to that particular quarter. And that's, you know, I did the additional form, or I had my CPA do it and everything. But what do? They credited the first audit. That since was, and I was told by management, oh, we can't, it's already been posted. We can't do anything about it. You're gonna find between the two accounts, there's been $300,000 that has been collected to something that should have been set aside until we reach this point today. I tried to offset and then incurred penalties, interest, and some other charges along that. So I point to you some of the things that I saw, and probably don't have all of the information, but one of the things that strikes me the most is how easy it can be in order to change this, and that's the direction that I would be going, but hopefully we can work something out. And I thank you. I thank you for your patience, and as my son was, we have some construction going on one of the stations, but the contractor said, your dad's got a lot of stories to tell. And I said, yeah, you know, I've lived them, proud of them. I thank you very much. She mentioned a good point, the questions, the additional questions that are on there. Would you like to go through those? Probably should. The 4 questions on period 1 and the 3 questions.
The
I've kind
issue
of
statements.
I've kind of skipped around a little bit.
Sure.
Okay. All right. So the one, number 1, I've responded. Further adjustments. I mentioned this, the adjustment for this, being the adjustments that I made on the credit versus cash. And then the hot fuel that I mentioned, right? The hot fuel that I mentioned, that I got somebody, and I think it was about 15 pages of engineering, you know, an engineering explanation of hot. That wasn't my intent. My intent was the adjustment. All I would have had to do was just to leave out the volumes. And number 3, what appellants have established as propanes are exempt. They're absolutely agree at this particular point that I am charging for sales tax, and it's paid on a every 3 months basis. So if a customer comes in, whether they are getting fuel in a truck, in a catering truck, or whether they're getting a 5-gallon, they're getting charged sales tax.
So for the liability period 1, are you still arguing that propane should be exempt?
I didn't collect it.
I understand there's a difference from charging and collecting it versus whether or not you have some sort of basis in the statute or regulation for its exemption.
It's in there. It's in my submittals. The actual regulation. And what happened was it was actually through the oil company. The oil company had us fill out a form, and that's what it's based on. I'm looking for a resolution on an overall basis, recognizing that, okay, I've corrected it, going forward. And I think in good faith, I've paid a whole lot more. At this particular point, I'm over between legal fees and fees that I've paid to the CDTFA for penalties, this, that, for offsetting things. I'm over $1 million in cost. And so I'm looking at this, if that's what it takes to resolve the other issues, or if it's just, you want to address that issue by itself, which is apparently what you want to do. I think we could, safely say, I didn't collect it, but, the funds from the consumer. The profits may have been there, but I didn't collect that. But every other thing that I've paid since this is the taxes. I think this particular account goes back 35 years. Everything's paid except for the items that I was not aware of. And I was told that this was the proper way of doing it by the same people. My team of auditors in the Van Nuys office.
You were told orally or in writing?
Always orally, over a cup of coffee, as they got their break, and they would go on a coffee break. Oh, what's going on, Andre? And I tell them, I'm an open book.
Okay, let me see.
Yeah. On the mini market sales, cigarettes, that's what comprises the majority at that time. And there was no rebate. The rebate that they refer to is not the rebate they're thinking. The rebate is actually a gasoline volume rebate that the oil companies paid at that time. But it's insignificant. I'm looking at the total picture. And my strongest point is your acknowledgement that on the first audit, that the first
quarter.
Yeah, that you acknowledge that the last quarter, was wrong, and you went ahead and you recalculated, well, what happened to the other? And I have notes here that says that, basically you would do an audit that way. Under your premise on the viability, on the under the prior percentage of error rule, you would use that for the whole audit. And I've got counsel that agrees with me that, so in fact, they highlighted that, that's one of the first things I need to look at. So, and then the negligent penalty, I've explained that if I didn't reach, because the key thing they said in the thing, if I didn't reach out for counsel or for ideas or from the auditors next door, that was my source, and this would have been early 90s.
Anything else to add on with respect to the second liability period?
The second liability, and I have it written in bold letters on it, is the prior percentage of error. There's a number of references to that because I didn't sign the forms, that they're going to base it on the prior audit. And then they did the same thing to the future audits. That comment was the same. And then, like I said, which, the double billing to the 76 Ocean, which was the corporate name of the Wilshire station, that taxes were paid through Jalidat, and there's duplication of that I identified under the names. You have that. You have copies of that already in there, that 76 Ocean is attempting to collect, or the CDTFA to this day, on 76 Ocean. In fact, that really strikes me as being, if I was trying to do that in the corporate world, I'd get nailed right off the bat. How can you collect for the same items, same periods? Doesn't make sense.
Does that conclude your opening?
Yes.
Okay,
Thank you very much.
thank you. So I think at this time, we're going to take a brief recess for about 10 minutes, go off the record, and we'll resume at 11 o'clock. Okay? Thank you. All right, welcome back, everyone. Thanks for the short recess. I believe we concluded appellant's opening, and so at this time, I'm going to ask respondent or CDTFA if they have any questions for the witness.
We don't have it. We don't have any questions, Judge.
Okay. This time, I'm going to refer to the panel members. Judge Long, did you have any questions for appellant?
No questions, thank you.
And hearing officer Wilson?
No questions at this time, thank you.
All right, so we'll move on to the combined opening and closing for respondent.
Thank you, Judge. Pellant, a California corporation, operated 4 gas stations.
Mr. Samagrima, sorry to bug you, but could you get that mic a little bit closer to you?
Yeah. Pellant, a California corporation, operated 4 gas stations with mini markets in the cities of Tarzana, North Hills, Santa Paula, and Simi Valley, California. Pellant sold gasoline and diesel at all 4 locations. Pellant also offered car wash service at the North Hill and Simi Valley locations, and propane sales at the North Hill location. Pellant ceased business operation of the Tarzana location on June 30th, 2011, but continues to operate the remaining 3 locations. 2 audit periods are subject to this appeal. For easy reference, the department is going to refer to the audit period April 1st, 2004 through March 31st, 2007 as the first audit, and refer to the audit period January 1st, 2010 through December 31st, 2012 as the second audit. During the first audit period, Pellant reported around $45 million as total sales and claimed various types of deductions, resulting in reported taxable sale of around $37 million, and this is shown on Exhibit B, pages 107 and 108. During the second audit period, Pellant reported around $37 million as total sales and claimed various types of deductions, resulting in reported taxable sale of around $28 million, and this is shown on Exhibit J, pages 546 and 547. During our presentation, we will explain why the department rejected Pellant's reported taxable sales and part of claim deductions for both audit periods. Why the department used an indirect audit approach to determine mini-market taxable sales. How the department determined Pellant's unreported taxable sales and disallowed claim exempt sales for both audit periods, and why the department recommended negligence penalty for both audit periods for this Pellant. According to Pellant, they use their sales details from their source documents to prepare monthly sales reports for each location to prepare Pellant's sales reports, federal income tax returns, and profit and loss statements for the first audit period. These sales reports include mini-market taxable sales, fuel sales, and the number of gallons of fuel sold. For the second audit period, Phelan claimed they used their sales details from their source documents to prepare financial statements, and these statements were used to prepare their sales and use tax returns. The information provided did show how Phelan derived their reported sales, taxable sales and exempt sales for the audit period. Based on the records available at the time of audit fieldwork, the department determined that Phelan's books and records were incomplete for sales and use tax purpose for the second audit period. For both audits, Phelan failed to provide complete POS download or POS sales records necessary to verify the accuracy of the amounts reflected on their sales and use tax returns. The department did not accept Phelan's reported taxable sales for both audit periods due to unusual reporting practices, recorded and reported sales differences, and low mini-market taxable book markups. Therefore, the department determined Phelan's taxable sales using Phelan's available monthly sales reports and other available records for the first audit period, and financial statements and other available records for the second audit period. During audit fieldwork for both audits, the department completed 6 verification methods to understand Phelan's reporting practices and verify the accuracy of Phelan's reported total sales, taxable sales, claim exempt sales, and tax credit. First, for each audit period, the department compared the recorded total sales reflected on Phelan's federal income tax returns to Phelan's reported total sales. For the period January 2004 through December 2006, Phelan's federal income tax return reflected around $54 million in sales, while reported total sales were around $43 million, resulting in an overall difference of around $11 million. And this is shown on Exhibit B, page 141. Similarly, the second audit period, Phelan's federal income tax returns reflected around $44 million in sales, while reported total sales were around $37 million, resulting in an overall difference of around $7 million. And this is shown on Exhibit K, page 701. The department noted that Phelan's federal income tax return sales during the second audit substantially match the total sales reflected in its profit and loss statement for all 4 locations, and these are shown on Exhibit K, page 699. Second, for both audit periods, the department compared the recorded taxable sales reflected on Phelan's sales records to the reported taxable sales. For the first audit, Phelan recorded taxable sale of around $52 million, while reported taxable sale of around $37 million, resulting in an overall taxable sales difference of around $15 million. And this is shown on Exhibit B, page 121. For the second audit, Phelan recorded taxable sale of around $42 million, while reported taxable sale of around $28 million, resulting in an overall difference of around $13 million. And this is shown on Exhibit K, page 665. Third, the department compiled recorded cost of purchases of taxable merchandises for first quarter 2007 by category for each store for the first audit period. And this is shown on Exhibit B, pages 133 through 137. Based on this information and the recorded mini market sales, the department calculated an overall mini market reported book markup of around 20% for first quarter 2007. And this is shown on Exhibit B, page 139. However, based on the short shelf test, the weighted audited mini market markup was around 63%. And this calculation is shown on Exhibit B, page 132. For the second audit, the department examined the available monthly sales reports for Pelham's mini market sales and determined taxable sales ratio of around 72% for North Hill location, 63% for Santa Paula, and 50% for Simi Valley, and no such records to determine the taxable sales ratio for Tarzana location. The department noted that the Pelham's first audit disclosed taxable sales ratio of around 74% for North Hills, 57% for Santa Paula, and 63% for Simi Valley, and 60% for Tarzana, and this is shown on Exhibit K, page 674. Fourth, Pelham made taxable propane sales at their North Hill location. The department noted Pelham claimed this taxable propane sale of around $1.2 million for the first audit period and $950,000 for the second audit period as exempt sales. And this is shown on Exhibit B, page 126, and Exhibit K, pages 676 through 680. Fifth, Pelham's Simi Valley location participated in cigarette rebate programs, while the other three locations did not. Based on the available contracts and sales records, the department found that these amounts received from the distributors represented taxable rebates because they required a selling price reduction equivalent to the amount of the rebate. Pelham failed to report their taxable cigarette rebates for both audit periods. Sixth, Pelham claimed credit for prepaid sales tax for gasoline of around $831,000. However, in comparison, Pelham's vendors reported to have collected from Pelham only around $801,000 of such prepaid taxes for the second audit period. And this is shown on Exhibit K, page 622. Similarly, Pelham claimed credits for prepaid sales tax for diesel of around $250,000. And in comparison, the vendors reported to have collected only around $209,000 for this audit period. And this is shown on Exhibit K, page 634. Pelham was unable to explain the reason for these unusual reporting practices. Therefore, the department conducted further investigation by analyzing available sales records for both audit periods to determine unreported taxable sales and overclaim exempt sales. For the first audit period, Pellant failed to provide their complete POS records that are necessary to verify the accuracy of Pellant's reported taxable sales and claimed non-taxable sales. However, Pellant provided federal income tax returns for years 2004 through 2006, monthly sales and expenditure reports, cash register tapes, sales invoices, and purchase invoices. The department compared the sale of Pellant's federal income tax returns to the sales reported on Pellant's sales and use tax returns and identify material sales differences. And these differences are shown on Exhibit B, page 141. In reconciling these differences, the department reviewed Pellant's monthly sales and expenditure reports and determined Pellant had recorded taxable full sale of around $52 million, but only reported around $37 million on their sales and use tax returns during the first audit period. And this is shown on Exhibit A, page 17. Pellant did not report their full sale of around $15.4 million for the first audit period, and this is shown on Exhibit A, page 17. Pellant contends that the amount of sales tax should be based on the number of gallons of fuel sold, adjusted for expansion that occurs at the fuel worms. Pellant also contends that the difference between recorded and reported fuel sales represent sales for resales to other vendors of fuel. In addition, Pellant contends that an adjustment is warranted for fees charged by credit card companies. The amount of sales tax is computed on the amount of Pellant sales with no adjustments for changes in the volume of gas. There is neither an exclusion nor an exemption related to fuel expansion. Moreover, in this case, the deficiency is based on Pellant's own recorded sales, and therefore any assertion regarding the alleged expansion of gasoline lack merit. Pellant has provided no documentation showing fuel sold for resale during the audit period to support their contention that the sale at issue were for resales. Further, Pellant did not register as a wholesaler of fuel until September 1st, 2008. And there is no evidence that Pellant accounted for or reported any fuel sales for resales prior to that date. Nor is an adjustment warranted for bank imposed credit card charges, since Pellant's gross sales include the total amount of retail sales with no deductions for cost of doing business. To understand product mix of Pellant's mini market, the department compiled recorded cost of purchases of taxable merchandise for first quarter 2007 by category for each store. And this is shown on Exhibit B, pages 133 through 137. Based on this information and the recorded mini market sales and cost of purchases, the department calculated an overall mini market recorded book markup of around 20% for first quarter 2007. And this is shown on Exhibit B, page 131. To verify the reasonableness of this recorded markup, the department performed a short shelf test on most popular taxable items using available sales and purchase invoices to calculate the audited weighted markup and an individual item markup. And these calculations are shown on Exhibit B, page 132. Pellant did not provide reliable documents to determine that their weighted taxable markup was lower than 63%. Therefore, this was the best available information to determine Pellant's audited weighted markup for their mini markets. Then the department used these audited weighted markup results and Pellant's taxable mini market purchases to determine accurate mini market taxable sales. Therefore, the department used first quarter 2007 cost of goods sold and audited individual item markup to determine audited taxable market sales for first quarter 2007. And this is shown on Exhibit A, page 13. Audited taxable market sales were compared with the recorded taxable sales to determine an unrecorded market taxable sales percentage of around 19%. And this is shown on Exhibit A, page 13. Then the department used the recorded market taxable sales and the unrecorded market taxable sales percentage to determine underreported mini market taxable sale of around $378,000 for this audit period. And this is shown on Exhibit A, page 12. During the appeal process, Pellant contends that the pilferage allowance should be increased, stating that they fired the store manager after discovering that the manager had stolen more than $60,000 over the prior year. Pellant claims that the manager's theft primarily represented theft of cigarettes. Pellant has provided no documentation of the $60,000 loss due to theft. Since Pellant failed to provide documents to demonstrate that the pilferage allowance should have been higher, the department finds no pilferage adjustment is warranted. The department also noted that the Pellant failed to report around $1.2 million in sale of liquid propane as taxable sales, but claimed those sales as exempt sales. These propane sales were assessed in this audit, and this is shown on Exhibit B, page 142. During the appeal process, Pellant contended that it is unfair to charge Pellant for a tax that was not collected. Pellant's failure to collect sales tax reimbursement from their customers does not alter Pellant's ultimate liability for the tax, which is imposed on Pellant for the privilege of selling propane and other tangible personal property. Therefore, the department finds no adjustment relating to this argument is warranted. In total, the department determined unreported taxable sale of around $16.5 million for the first audit period. And this calculation is shown on Exhibit A, page 16. The department then compared the total unreported taxable sales with the reported taxable sale of around $37 million to calculate the error rate of around 45% for the first audit period. For the second audit period, Pellant failed to provide their POS download or complete POS reports that are required to verify the accuracy of Pelham's reported taxable sales and claimed non-taxable sales. Therefore, the department conducted further investigation by analyzing Pelham's available profit and loss statement for the second audit period. Using Pelham's profit and loss statements, the department noted Pelham recorded gross gasoline sale of around $35 million for the 4 business locations for this audit period. And this is shown on Exhibit K, pages 676 through 680. Also, while the profit and loss statements also reflected non-taxable gasoline sales for resale purposes, the department found that the available information could not be used to verify the extent and nature of any sales recorded as being non-taxable. Accordingly, the department compared the recorded gasoline sales with reported gasoline sales to determine unreported gasoline sale of around $10 million for the second audit period. And this is shown on Exhibit K, page 665. Additionally, the profit and loss statement also reflected recorded gross diesel sale of around $4.3 million for the 4 locations. And this is shown on Exhibit K, pages 676 through 680. The department compared the recorded diesel sales with reported diesel sales to determine unreported diesel sale of around $1.6 million for this audit period. And this is shown on Exhibit K, page 665. Pelham disputes about the unreported taxable gasoline and diesel fuel sales and claim that the difference represents sales for resales. However, Pelham has not provided any documentation showing fuel sold for resales during the audit period to support their contention that the sales at issue were for resale. Therefore, the department rejected this argument. Pelham's profit and loss statement reflected recorded propane sale of around $958,000 and recorded mini market sale of around $2.4 million for this audit period. And this is shown on Exhibit K, pages 676 through 680. Based on the available monthly sales reports for Pelham's market sales, the department calculated taxable sales ratio of around 72% for North Hill location, 63% for Santa Paula, and 50% for Simi Valley. No records were available to determine the taxable sales ratio for Tarzana location. The department also noted that the first audit disclosed taxable sales ratio of around 74% for North Hills, 57% for Santa Paula, 63% for Simi Valley, and 60% for Tarzana. And this is shown on Exhibit K, page 674. Therefore, based on the first audit, the department estimated 63% taxable sales percentage for Santa Paula, Simi Valley, and Tarzana locations. And this is shown on Exhibit K, page 674. Based on these taxable sales percentages, the department calculated audited mini market taxable sale of around $1.6 million for this audit period. And this is shown on Exhibit K, page 674. The department has compared the audited taxable market sales and propane sales with reported taxable market sales to determine unreported taxable market sales, including propane sale of around $1.6 million for this audit period. And this is shown on Exhibit K, page 665. During appeal process, appellant disputes the unreported taxable mini-market sales and propane sales, but has not provided a specific basis for their dispute or any additional evidence or information to substantiate errors or adjustment in this regard. Accordingly, the department finds that the appellant has not established a basis for which it can order any adjustments. Based on the foregoing, the department finds that no adjustments are warranted to the unreported mini-market taxable sales, including propane sales for the second audit period. Appellant Simi Valley location participated in cigarette rebate programs, while the other 3 stations did not. The department examined appellant's contracts with cigarette distributors and found that some of the amounts received from the distributors represented taxable rebate income because the distributors required a selling price reduction equivalent to the amount of the rebate. Appellant failed to report their taxable cigarette rebate for this audit period. Therefore, the department determined unreported taxable cigarette rebates of around $57,000 for this audit period. And this is shown on Exhibit K, page 696. During the appeal process, appellant disputes the unreported taxable cigarette rebates for the second audit period, but has not provided a specific basis for their dispute or any additional evidence or information to substantiate errors or adjustment in this regard. Accordingly, the department finds that the appellant has not established a basis for which it can order any adjustments. Based on the foregoing, the department finds that no adjustments are warranted to the unreported taxable cigarette rebates for the second audit period. In total, the department determined unreported taxable sale of around $13 million for the second audit period. And this calculation is shown on Exhibit K, page 665. The department then compared the total unreported taxable sale of around $13 million with the reported taxable sale of around $28 million to calculate the error rate of around 47% for the second audit period. When the department is not satisfied with the accuracy of the sales and use tax return file, it may rely upon any facts contained in the return or upon any information that comes into the department's position to determine if any tax liability exists. A taxpayer shall maintain and make available for examination on request by the department all records necessary to determine the correct tax liability under the sales and use tax laws, and all records necessary for the proper completion of the sales and use tax returns. When a taxpayer challenges a notice of determination, the department has the burden to explain the basis for that deficiency. When the department explanation appears reasonable, the burden of proof shifts to the taxpayer to explain why the department asserted deficiency is not valid. Since appellant failed to provide their available POS records for audit period, the department used the best available information to determine the unreported taxable sales and overclaim exempt sales for both audit periods. The audit calculation of unreported taxable sales and overclaim exempt sales based on the best available information was reasonable. Finally, the department properly imposed the negligence penalty for both audit periods based on the substantial understatements and the appellant's errors in preparing their sales and use tax returns. Appellants significantly understated their reported fuel sales and propane sales during both audit periods. The total error rate for the first audit period was around 45%, and for the second audit period, around 47%. Error rates of this magnitude demonstrate a failure to exercise ordinary care in reporting sales tax liabilities and support the imposition of the negligence penalty. Appellant has not provided any reasonable documentation or evidence to support adjustments for both audit periods. Therefore, for all of these reasons, the department requests the appeals be denied. This concludes our presentation. We are available to answer any questions the panel may have. Thank you.
Thank you, Mr. Semaragrima. I do have a few questions for you. So one of the arguments that appellant raised is that respondent made an adjustment first quarter of '07, and that change should be projected to the rest of the audit period. Why should or should that not happen? So if it helps, I believe there was a submission from CDTFA dated June 27th, 2024, which explains the adjustments.
If you may refer to page 14 of Exhibit A. That the appellant provided the detailed sales information for the first quarter 2017, and it specifically says tax is included, but not the other quarters. The page 14, Exhibit A. So that's the reason that we didn't project it, because it specifically says tax was not included.
Okay, and for the other quarters of that audit period or liability period, one, there was no other evidence to suggest that sales tax was included?
That's correct, Judge.
Okay. All right. Another question for a respondent. Appellant has raised the Norm Rice model in briefing, and I guess my question is to respondent: was the Norm Rice model used to compute any portion of the audit?
Based on the audit reports, the department used the taxpayer's own records to determine unreported taxable sales.
So the understatement was calculated using records, the difference between recorded and reported?
That's correct, Judge.
Okay. It does look like, however, the Norm Rice model was used to compute expected fuel sales, but that the department didn't rely on that in producing the understatement. Is that correct?
That's correct, and we only use that to determine the reasonableness or the accuracy of the recorded sales.
Okay.
Yeah.
And appellant raised some questions about the Ocean 76, and I guess my understanding is that Ocean 76 wasn't petitioned from I don't know if there's a decision or if that went final already, but I presume that it has since it's in collections. Is that Ocean 76 a different location than the four locations that involved audit period 1 or liability period 1 and 2?
The that location is registered under a different entity, and the audit period for that location is same as the second audit period, that is January 1st, 2010 through December 31st, 2012. And those sales related to that Santa Monica location is not part of this audit.
Okay. And in the briefing, there's reference to like a Sepulveda location or a Roscoe location. That's the same as the North Hills location, is that correct?
Yes, Judge.
There's just 3 different names, so I want to make sure that I'm referring to the one location under the correct name. Appellant, if you'd care to respond to that same question.
They're the same.
Okay. And then with respect to liquefied petroleum gas, is the department aware of any exemption in the revenue and taxation code that provides for either an exempt or partially exempt sales for food trucks?
Can you repeat the question, Judge?
To the department's knowledge, is there a revenue and taxation code section or corresponding regulation that exempts sales of liquid petroleum, i.e. propane, to food trucks if it's above a certain size tank?
No.
Okay. My understanding is that Revenue and Taxation Code Section 6353 provides an exemption, but that's to qualified residents or a qualified person using it in harvesting agricultural products. Mr. Vandervalk, is there a code section you can point me to with respect to the potential exemption for propane sales?
If I'm not, I believe that's the same code that also talks about in the process of food preparation. It's not just agriculture.
You think the food preparations in the Revenue and Taxation Code or the regulation?
In the revenue taxation code.
Because I have it in front of me and food preparation doesn't appear.
Your Honor?
Yes.
What was the date of that?
So the stats brought it into effect in 1972. There's been some changes, but none of those changes include food or food preparation.
Because it distinctly, and that could have been right around, I would say, the 1990, 99, somewhere around there, just before the 2004.
Okay. And I guess I'd point out that there's a court case called Standard Oil Company of California v. State Board of Equalization, 1974, 39 cal.app.3d 765. And if you were to pull up that, I guess the highlight of it is that delivery of liquefied petroleum gas by hose from vendor's tank truck to buyer's storage tank is not exempt. So that's like another area that you might look at, but food doesn't appear to be in that code section. So I guess if there's another one that you'd like to direct the panel to, that'd be helpful.
It would be in the third and fourth audit, because that's when I went ahead and said, okay, I've collected since then. And that would be the audit number 3. I have that.
Okay, I think I understand. I guess I'm going to refer to the panel to see if they have any questions. Hearing Officer Wilson?
I do have a question for the department. The appellant mentioned a prior audit percentage. I did note on Schedule 12D, which is page Bate Stamp 674, that there is a percentage per prior audit. Was that percentage used in the audit?
That is for the second audit period to determine the minimum taxable sales. So it's from the first audit, the department calculated the audited minimum sales, taxable minimum sales to the total, and use that percentage to determine audited taxable minimum sale for the second location. Second audit period. The department used those percentages, yes, for the minimum.
Okay. I thought it was just a comparison of what was calculated to the prior audit. Is that not correct?
For the second audit period, the department calculated for the 3 location, and the department did not have the information to calculate for the Tarzana location, and the North Pole location was 63% based on the second audit information, and for the other 2, Simi Valley was less, 50% if I'm correct. So basically, for Santa Paula location, Simi Valley location, and the Tarzana, the department used 63% from the first audit period, the taxable percentage to determine taxable minimum sale for the second audit period for those 3 locations.
Okay, thank you.
Yeah.
That's all I had.
Hearing Officer Wilson, I just wanted to clarify one thing. And I'll do my best to find the page number in the exhibits. But the 63% was actually calculated on 12J3, and that was what was carried forward. So it appears that we used that calculation to determine the 63% that we applied to the other 3 similar locations. And we used the 72% on 12D for the, let me get to it, for the North Hills location. And it was just a comparison. So it wasn't, we didn't apply the prior audit percentage or the prior audit taxable ratio to this audit. It was a comparison.
Thank you.
Judge Long?
No questions, thank you.
Okay. You have a question, ma'am? Sure.
As far as the $60,000 cigarettes that were gone, we're a family, and the young man that did this also had 2 small kids, so we just fired him. We didn't file a police report or anything. That's just how he had been with us for probably, 10, 12 years, had a young family, so the decision was just to fire him. We didn't file charges.
Thank you. At this time, I'd like to give you the opportunity to provide a rebuttal or a closing statement of 5 to 10 minutes.
Thank you, Your Honor. I paid attention to all that was said by the representatives from the CDTFA, and it's all documented. It's all, of what they did and what had been done, and quite frankly, it was gone over prior to me leaving council last year. That was all, I know what we're talking about, and basically, if you take a look at the big picture, we from day one were identified as a card lock in multiple locations. And that identity and how to treat that was not referred back to the December 16th, 1994 letter by your counsel that indicated on how to treat Mr. William Dunn, Assistant Principal Tax Auditor. It's 382, 383, and 384. And I state that that comment that I indicated that was used is the prior percentage of error. It's all over the place on that second audit, and it was in practicality used on the first audit and the review audit. How can you be sitting there and cover this and look at it and recognize that there's inconsistencies, plus there are contours? How do you take that that last quarter, that it was the first quarter of 2007, and not extrapolate that among the prior audits? That goes against any of the audit principles that they're used. So the premise still today with the auditors is that, welcome to the audit. Oh, well, we don't use that, in the past and everything else. Well, and then they go ahead and they use, if you don't, they don't have time right now, auditors. They don't have time. They want you to sign that form. If you don't sign that form, guess what? It's going to go ahead, it's going to go into, then the form I'm talking about is the extension. Okay. If you don't file an extension form, I will guarantee you that the auditor is going to use the prior percentage of error. There's no doubt about it. If you don't pay it, still to this day, then guess what? You're going to have to come up with the money. That's the solution. Oh, you have to come up with it plus the, whatever interest and this and this and that. Well, wait a minute. I don't have that kind of money. I don't make that kind of money. And so I had to offset. Well, guess what? That opens up past Pandora's box, where you're either going to do what collection says, and that's what happened last year, or you make some major changes, and that's what happened. So that is still true today. As recently as last year, when I had an audit from the Ventura office, I reminded them, wait a minute, I still have 2 audits. One was resolved. I still have 2 audits in the past. What would you do? Well, if you don't sign this form, then we'll give you a week to come up with everything. And I said, okay. I came up with everything. But meanwhile, guess what model they used on the volumes? It was the same thing. It was the norm price model. That's how they get it. What's ironic about it is that all through this, guess who now I have Chevron, 76, and Valeros. That's the representation right now. All 3 of them Guess what they do? They provide you the volumes that have been purchased. Why? Because they realize that there's inconsistencies in the CDTFA. And so if I go into an audit now, I can produce a form that's put out that's based on the Norm Rice model. And that's strictly volume and dollars paid in. And then they even show the prepay on that. All I was trying to do was to highlight there's lack of consistency from day one. As far as the calculations, I defer any one of these gentlemen representing the CDTFA to tell me how to charge diesel fuel and what the resulting state taxes are and the resulting profits to the operator. I will guarantee you that if you do that with dealers, 10 dealers, you can sit them down and you say, okay, figure out the diesel margin and figure out what the sales tax is on it. And you're gonna get 10 different answers. What does that tell me? That tells me that something's wrong with the system. And that's what you're seeing right here. Something wrong with the system, but somebody having the fortitude to carry it forth. And yet questioning, I had to take a pill because I have high blood pressure, because I had open heart surgery, a 6-way bypass in 2013. I made that meeting in 2015 before the BOE board. I was still hurting, but somehow I was anxious to get it together. That's why I'm so emotional attached to this case at the level of dollars that it represents, which could have been handled in 2015. For some odd reason, it wasn't. That's it. Meanwhile, you mentioned that the 76 Ocean is in petition. I'm not so, maybe a fancy word to me, but the 76 Ocean, I was told by the collections person not to worry about it, that that's not an issue. And you think, well, wait a minute, you know, I'm still getting letters. So I don't know if that means that it's in petition or what, but it does have an impact on what transpired on the second audit, because you're trying to collect monies, and I highlighted it in red, but you're trying to collect monies from two different sources that were reported in the original audit through Jalidat. And the reason why I have Jalidat doing, there were so fancy numbers. You hear 3 million, 6 million, 30 million, 40 million. You know, we're dealing with gasoline. But today we're heading right back down to over $5 a gallon. And yet they're basing like it was $3.50 or $4 in terms of what they're collecting as far as prepay is concerned. It's still occurring. Nobody's taken the time to look at it, and instead of looking what, you know, this case is all about, and I'm sure I'm not the only one. There's other cases out there. And you look at it, and like I said, if that's a fancy term for that it's in petition, I can show them the documents that say, no, you actually tried to clear it out of my business account last year. Here it is, boom. And it was late last year. Finally, the audit represented a lot of numbers that said that they were similar locations. Absolutely not. The Roscoe location, my wife mentioned about firing, and we have, you know, that's a big decision. My attrition among employees, I have 30 employees roughly in 4 stations, and my average employee has been there for 13 years. So we don't have turnover too much, and it's a major disappointment, and it hurts you when something goes wrong. Small bearing, and all of a sudden it's been brought up. It's been brought up about me, you know, about us letting somebody go. He was selling cigarettes and dealing with propane on the side without writing it up. It was as simple as that. We caught it, we did it. And so, as far as the similar locations, it's a kiosk. How can you compare a kiosk with heavy cigarette sales at a low margin with no rebate to a food mart in Simi Valley that sells a lot of product, including the largest sale of vending machines is Aquafina. Aquafina is made by Pepsi Cola. Pepsi Cola. Who would think that it outsells any of their other products? And it's the biggest name in terms of water sales on there. It's non-taxable. That's what's being sold out of locations such as Simi Valley. They'll go ahead and they'll get fuel, and then they'll go ahead and get water. I know the business, Your Honor. I know the business well. There was no mention, it was never brought up, but there was that 1994 letter from the state board to the commercial fueling network that says it all, and that was in 1994. I was a young guy then. And that letter was never referred to in any of the audits that I've had. Had that letter gone out, and if it still goes out to the auditors, say, hey, look, this is a reminder. Hanging on to that one, that my recommendation or my call it accusation is, and it's based on merit, is that you're not getting numbers from the end user that's charging. I will guarantee you that if I can get a Voyager card, I will trace it back, and I will show you that the end user is not being billed the sales tax that is at the pump. Why would I say that if I didn't think that that was true, or if I didn't have the basis that that was true? And my reflection upon what I said was going on at the Simi Valley location now, which was the actual charge were 30 cents a gallon, and it cannot go, it's being shown as a credit card fees. Chargebacks, as chargebacks. I'm still making hand calculations. So it just, I leave it at that. I appreciate my time here. I thank you. It was exciting making it up here yesterday between snow and hail and water. We love Tahoe. But we're not used to going up here in the middle of February, but we need the rain, and I'm glad we're here. I share with you my enthusiasm of having a large account like this being looked at, and I appreciate that. My wife and I appreciate it. I thank you very much.
Thank you, and thank you for your time. One moment. Well, I want to thank everyone for their time. We're ready to conclude the hearing. The record is closed, and the time to submit evidence is now closed. The panel will meet and decide this appeal on the admitted evidence, arguments, and relevant law. We will send both parties our written decision no later than 100 days from today. And OTA's hearing calendar has concluded for the day. And please cut the live stream.